sets a goal to remediate pollution due to releases from underground storage tanks. TDEC furthered that goal in this matter by promptly remediating a release that the petitioners discovered on their property in 2010 in Millington, Tennessee. TDEC cleaned up this release and the contamination therefrom on an emergency basis because this release occurred within a wellhead protection area where the groundwater was a source of drinking water. So there was a serious concern for public health and environmental protection that required prompt action from TDEC. After TDEC remediated the release, they sent a bill to the petitioners as responsible parties, and that bill came in the form of a cost recovery order. Petitioners administratively appealed that cost recovery order to the Board of Underground Storage Tanks. The board ultimately issued a final order finding that the order was properly issued because petitioners were responsible parties and petitioners had failed to show that the UST Act did not apply to the release. After losing before the board, petitioners then sought a judicial appeal to Tipton County Chancery Court, which reversed the board's decision erroneously.
I'm sorry, why did it go to Tipton County?
That was due to recent changes under the Uniform Administrative Procedures Act, which allows for aggrieved parties from a final agency action to challenge that decision in the Chancery Court that is closest to their residence.
Okay.
It used to be that these challenges were heard exclusively in Davidson County, but now we get to travel more across the state. The board correctly ruled that TDEC's cost recovery order was properly issued because petitioners are responsible parties as owners of the petroleum site, and the UST Act applied to the release at issue. I'd like to begin.
Let me ask you a question before you begin, and give me a little background here. I'm looking at the act itself. What's the significance of the November 8, 1984 date?
I am not sure offhand what the significance, you're referring to the definition of owner and to whether the owner of a tank put into use before 1984.
Right. Prior to November 8, 1984, under the owner definition. I'm trying to make this act make sense.
It is a somewhat confusing act, I agree, Your Honor. Luckily, for purposes of this case, we would argue that that definition of owner, which is restricted to describing ownership of tanks, simply has no applicability because we are asking and answering the question of who is a petroleum site owner. I think that 1984 date may come into being because of federal standards for those tanks that may have been put into place in 1984, and the reason for Section 102C's cutoff for when the UST Act applies and why that is based on July 1st of 1988 is because that is when the UST Act standards for how tanks must be maintained, operated, and monitored went into effect. So I believe it's setting the rules based on when standards went into effect. But again, we're asking whether petitioners are responsible parties, and that has 4 separate definitions, the first of which is the owner and/or operator of a petroleum site. Petitioners clearly meet that definition, Your Honors, because they admit they are the owners of the property where these tanks were discovered. And the UST Act defines a petroleum site as any site or area where a petroleum underground storage tank is located. Therefore, under a plain reading of the Act, petitioners are owners of a site where a tank is located. Petitioners are petroleum site owners. Now, petitioners attempt to avoid this plain reading of the Act by focusing on the definition of owner under the UST Act.
Well, what about whether or not they were petroleum underground storage tanks? Were the tanks themselves tested to determine whether they had held petroleum at one time?
Your Honor, the tanks were not tested, but the board made findings that because of petitioners' actions of once they discovered the tanks in 2010, they did not notify TDEC as they should have done. Instead, petitioners removed the tanks and impacted soil to their personal property, and the tanks sat out for over a year in the elements.
Well, in the statute itself, 106, doesn't it say that tanks that were taken out of use prior to a certain date, that there is no notice requirement to the commissioner?
If they were taken out of service before that particular date. But, Your Honor, the tanks were excavated, in this case, in 2010.
Is
That
it the
is,
excavation, or is it the use that triggers the date that we're talking about?
Your Honor, a tank is in use so long as there is petroleum substances within it. That's why TDEC's regulations specifying when a tank must be put temporarily out of use requires the owner or the operator to pump that tank down. If there is still material within that tank, it is still in use, and that tank still poses a potential threat.
How do you know there was material in these particular tanks?
Your Honor, I don't think that there is a finding of when the material specifically left the tanks. There was discussion and findings and evidence presented in the record that the contamination that TDEC cleaned up, originated on the Millington and petitioner's property.
And that, wasn't there a service station across the street that also had contamination issues?
Correct, Your Honor, but TDEC put on unrefuted expert testimony that the contamination at petitioner's property was separate and distinct and was originated from a separate release than the contamination found at that veterinary hospital. So we have two separate releases here, and the board concluded that the release at petitioner's property originated from the tanks that petitioner excavated in 2010.
But they were unable to say when that release occurred.
Correct, Your Honor, because under the statute, all TDEC must demonstrate is, well, really the prima facie case that the board lays out on page 1119 of the record, that's in volume 9, does not include any requirement for TDEC to demonstrate when a release occurs. All TDEC must do is demonstrate there has been a release of petroleum product from an underground storage tank, and when it's issuing a cost recovery order, that the petitioners or the respondents are a responsible party for who bears a portion liability. TDEC met all of those requirements. Even if you believe TDEC does have some burden to demonstrate when a release occurs, it met that burden by relying upon the statutory and regulatory definitions that establish a legal rule on when a release occurs. Because it can often be difficult to factually determine when a release occurs. We can't go out and use our X-ray vision to look under the ground to determine when these tanks start leaking. So the General Assembly and TDEC gave us clear legal rules that say the date of discovery of the contamination is when the release occurs. And those legal rules establish a rebuttable presumption or a point of departure.
And how do you rebut that presumption?
You rebut that presumption by, let's imagine the Texaco case, Your Honor, where the release was discovered in 1991, but the tanks had been removed in March of 1988. So the only way there could have been a release from those tanks to the environment was while the tanks were still in the ground. So there was additional factual information that indicated the date of the release predated the cutoff date in Section 102C.
Well, in this situation, we know that from the evidence in the record that I recall, there was a prior owner that nobody had used this as a service station or was even aware that there were underground tanks. until there was this excavation process, and the service station that was in existence predated the November 1984 date.
I agree with all of that, Your Honor, but importantly, the petitioners in this case did not do their appropriate due diligence before purchasing the property. And members of the board noted and were concerned that that appropriate due diligence had not been done. I'll refer the court to page 4,349 of the record. That's in volume 31, where the board member Pat Flood said, "I'm very surprised that a phase one had not been performed. I think had there been a phase one performed, which is usual and customary, they would have discovered the fact that there had been a filling station at this site." The burden is on potential purchasers to investigate and determine all known environmental liabilities on their property before they purchase it. Petitioners' failure to do their due diligence is not grounds to force the UST fund to bear the full cost of this remediation when petitioners are the owners of the property, and ownership of the property is all that is necessary under the UST Act to be classified as a responsible party who bears the costs of remediation.
It seems like in reading the briefs, the tanks were referred to as small tanks. The tanks that were recovered, are they of the size that you would expect to be found underground if that site had been operated as a service station?
I do not know the answer to that, Your Honor, but the UST Act does not, I believe, create a cutoff below which there is a minimum size for regulation. It regulates petroleum underground storage tanks. Now, petitioners attempted to argue as an affirmative defense that these were certain farm tanks or contained materials that were excluded from regulation, but the board determined they failed to carry their burden as an affirmative defense to show these were not petroleum underground storage tanks that are regulated under the Act.
Let me ask you one other thing. As I understand from reading the briefs, the amount of contamination found on the petitioner's property was extremely low. Why would that not be evidence that the contamination found was a spillover from the adjacent property where they had tanks and there was a leak? Because if there's a leak, it wouldn't just stop on that owner's property. It may very well flow onto adjacent property. How did the commissioner prove that it wasn't a spillover from the other property where we know there was a leak?
Yes, Your Honor. I will refer you to the testimony and evidence put on by TDEC's expert witness, Rocky Hanna, who is a geologist, and he looked at the sampling and groundwater data that showed the release originated on petitioner's property because there were higher numbers on petitioner's property that ebbed as they went off towards the veterinary hospital property. And then when you got to the veterinary hospital property, they went up again. If all of the contamination had originated from the veterinary hospital property, you would have seen a slow but steady gradient with the highest point at the veterinary hospital gradually decreasing to petitioner's property. That was not the case here, Your Honor, and the board concluded that the release originated on petitioner's property, and therefore petitioners were responsible parties whom the order had been properly issued against.
All right.
I see I'm out of time. If there are no further questions.
Hearing none at this time. Thank you, Mr. Murray. We'll hear from the appellee. Good afternoon.
Good afternoon, Your Honors. My name is Stephen Roberts, and I represent Marlin Roberts and Angela Roberts, the appellees in this matter. Let me address the last question that was asked first, and then we'll go back. The testing done at both facilities. There's a street going between the two. There was no testing whatsoever, any well samples taken from the street to make that conclusion. When Mr. I can't even remember his name, the expert was testifying, he acknowledged that water carries contaminants and it ebbs and flows across the properties. You know, when water level goes up, because we had multiple pages, as you can see from the record, of different samples of elevations of the elevation of the water back and forth, it would flow and of course take contaminants back and forth. That was part of our argument as well. But the real issue is, well, let me back up. The brief of the appellant states that the issue is whether the board's decision should be affirmed. Well, this is an appeal from the Chancery Court, and the question is, did the Chancellor err in finding that the decision of the board was incorrect and that she was basically, in essence, reversing that as being arbitrary and capricious and not following the correct standards? And that may be a little technical issue, but I think it comes into play when we look at what we should be doing here on the appeal. The issue, because this is questions of law, all reviewed de novo, without any presumption of correctness from the prior findings, and the Uniform Administrative Procedure Act specifically provides that in interpreting a statute or rule, the court presiding over the appeal of a judgment of contested case, which this clearly was, shall not defer to the state agency interpretation, and the court shall interpret de novo after applying the customary tools of interpretation of a statute or rule. The court shall resolve any remaining ambiguity against agency authority. And I give that brief introduction just because when we look at this case and the definitions provided and what the statute is, we have a situation where we have an issue of a release, which is defined in the statute. We have the issue of who a responsible party is, and that's defined in the statute. What happens is the agency wants to say, well, that's not what it means, or we're not going to use that. We're going to go to our regulations. And the regs define certain things, and the only thing that is in the regulations that is not in the statute is that the regulations have a term called date of release. And you would think, okay, well, we apply that to the fact situation of this case, and we end up with a situation where, well, it says date of release. So, you know, and we define date of release as when it was discovered. That's nowhere in the statute. And if you look at the date of release in the regulations, it is only used in the regulations to determine payments under the fund. It's like a insurance policy. It says, you know, when we discover this, you know, you're paid based on this date of discovery. It has nothing to do with when the release actually occurred. And that's what they're wanting to do, is add that date of release to the statute, which it's like, well, the statute does the same thing with the term occurrence, which is a date of discovery. In the statute under section 111, and that's the only place occurrence is used in the statute, it says, it talks about payments from the fund per occurrence, and that's the discovery of it. We don't have that issue here. There are two types of cases. One is a fund case, which would apply to the occurrence and the date of discovery issue.
But
And the other is a non-fund case.
Is this a fund case?
This is a non-fund
That's what I
case.
was thinking.
Yes. And so when you look at it, and if you look at the regulations too, it talks about the regulations being used for the payment under the fund, for financial responsibility under the fund and under the regulations. That's what it's for. It's not
So-
talking about
So
payments
that-
from,
So that does not apply?
that does not apply.
Okay.
Okay.
That's what I'm-
And then we look at the legislative intent, and the state wants to argue that this is a remedial statute, and therefore it should be given broad discretion, broad interpretation, liberal interpretation. Well, the same statute that created this also limited it, because the legislature said in section 102C, the intent of this chapter shall not apply retroactively to releases. It doesn't say releases or occurrences or other events that occurred prior to July 1, 1988. So the burden is on the state, or on the agency in this case, to prove that the release occurred prior to July 1, 1988. And in the record, there is no date of when this release, the actual release of any petroleum products, occurred. Cindy Storm, the deputy director, acknowledged on page 82 of her testimony in the original record, cannot state when the tanks were installed. She couldn't testify when the tanks, what they contained, and couldn't give a specific date when the ground at the transmission doctor property became contaminated. And so, because the state can't prove a date, and the administrative law judge before the board advised the board that they had to prove that. Well, to get around that, the board decided, the board said the date of the release is the date that it was discovered, which was in 2010. Nowhere in the statute does it say that. That is not a requirement or a provision in the statute. It says release, and it means release. The agency wants to say occurrence means release. Well, those are two different definitions in the statute. And because they are different, they don't mean the same thing. We've got to apply the plain language of the statute, and because the statute gives us definitions, we have to use those terms. And that brings us to the issue of a responsible party. Who is a responsible party under the Act? Well, a responsible party is the owner and/or operator of a petroleum site, okay? So we look to what is a petroleum site, and we go up to, these are in section 103, and this is section 13 defines a petroleum site as any site or area where petroleum underground storage tank is located, okay? Got a petroleum site with an underground storage tank. And it defines owner or operator, and that's in section 9 and 10 of 103. Owner, operator clearly doesn't apply because we don't have any operation of the tanks. So we look to the term owner, and in that we have, it says, for a petroleum storage tank in use or brought into use on or after November 8, 1984, any person who owns a petroleum underground storage tank for use or storage or dispensing petroleum products. Clearly, Section A doesn't apply because Mr. Kirkendall bought the property in October of 1984, and he didn't know there were any storage tanks there at all. I mean, he never discovered any as long as he owned it. So we go to section B. And it says, for a petroleum underground storage tank used prior to November 1, 1984, November 8, 1984, but no longer in use after that date. So clearly, this one would have to apply as the owner, and defining who the owner is. The person who last owned the petroleum underground storage tank used for storage, use, dispensing of petroleum immediately before discontinuation of its use. That's the owner under the statute. The agency never found who that person was. They want to, in turn, create a new term. They want to say petroleum site owner, and we define what that term is. Even though petroleum site is defined in the statute, owner is defined in the statute, they want to change a responsible party under Section 17A1 to mean what they want it to mean, petroleum site owner, and then they want to define it. And they say, oh, we want to use our regulations for that. Well, their regulations don't define petroleum site owner. Nowhere in there. But it's something that they want to do, saying because we discovered petroleum, or petroleum was discovered after this date, that you are a responsible party under the Act. That's incorrect. Under the Act, it specifically provides that the release has to occur after July 1, 1988. They can't prove or show when the release occurred, who the owner was, and therefore it doesn't apply at all. Then we come to the underground storage tank and how we interpret the Act. And because the Act is, in this one, is clear, it's clear, it's unambiguous, that we've got to use the terms that are provided, the definitions given in the statute, and because it is clear and unambiguous, it's got to be interpreted with the terms given, and because it's clear and unambiguous, there's no ambiguity to be determined, the statute has to be interpreted and relied upon the way that it is. It's not like, well, the state is wanting, or the agency, I keep calling them the state, the agency is wanting to redefine those terms and create some ambiguity that doesn't exist in the statute. And it's our position because of that, because they're wanting to create the ambiguity that exists, or the ambiguity they want to say exists, but where none really exists, the statute in this case doesn't apply to the Roberts and they're just simply being owners of the property. And the chancellor correctly found that they were not the, quote, owners or responsible parties under the Act merely because they were owners of the property at this time. Now, I do want to address one little short thing. In my brief, I did reference the spoliation of the tanks because TDAC said it was an emergency. They went in 2011, did the drilling and cleanup. They took the tanks in 2011. They destroyed them in 2014 without notifying the Roberts at all, saying, oh, by the way, in 2 years we're going to send you a notice of assessment. So in 2011, they seized the tanks. 2014, they destroyed them. 2016, 2 years after that, they send them an assessment notice. But yet, at the same time, what was an emergency in their case was not an emergency across the street, because that one was ongoing from 2012 to 2017.
Did you
And,
raise this argument in the trial court?
excuse me?
Did you raise this argument in the trial?
We did, and the trial court said that she didn't rule on the issue of spoilization because the issue of the release and responsible party resolved the problem. But I wanted to say, I only mentioned that in the brief in response to the issue of affirmative defense that was being raised by the agency, saying that there were certain affirmative defenses that we had to raise, and the court didn't rely on that. And I'll be candid, they just said that because the state had destroyed the tanks, that clearly prohibited us from, or prohibited the Roberts from inspecting and having them tested, and therefore we were forced, in essence, to accept the state's theory that they did contain petroleum.
All right, thank you, Mr.
Thank you.
Roberts. We'll hear a rebuttal.
Thank you, Your Honors. Two brief points on rebuttal. The first involves the construal of Section 102C, which petitioners are claiming we're saying that we are commingling definitions of release and occurrence. That it could not be further from the truth. Section 102C acts as a gatekeeper to the entire UST Act, based not on whether a release occurred or who caused the release, but when the release occurred. And I emphasize that word occurred because that's directly in 102C. And the question of when a release occurred is naturally answered by looking to the statute's definition of occurrence. And that term is defined as the discovery of the contamination. So under the plain reading of when a release occurred, that is answered by the occurrence definition, which states that a release occurs when it is discovered. Second, onto the definitional sections of responsible party. Petitioners place all their emphasis on the tank and time-specific definition of owner under the UST Act. But we're not asking whether the tank owner bears liability here. We're asking whether the property owner bears liability. And it is common and frequent for the owner of the petroleum site to be different than the owner of the tanks underlying that site. And the legislature created two separate categories, the first of which is the owner of a petroleum site. The court has no need to inquire who owns the tanks when answering the question, who owns the site. That question has already been answered because the petitioners admit they own the site. So we respectfully request this court uphold the board's determination in this matter. Thank you.
All right, thank you, Mr. Murray and Mr. Roberts, for your arguments. We will take this matter under advisement. That concludes the afternoon docket.